Okay, we're on the record now. People versus Jason Fish, case number 236591.
Very Brown and Mr. Fish. Mr. Fish present in court today?
Do not believe so, Your Honor.
Okay, Mr. Brown, have you had any contacts with him?
I have not with him, Your Honor.
Sorry, I was just looking something up to make sure.
I had a phone number for him, a primary phone number. That number had been disconnected. I had a secondary phone number, which apparently belonged to his then girlfriend. They are no longer together. She does not communicate with him. So I am unsure where he is.
Mr. Rolla, any objection to issuing a bench warrant for Mr. Fish's arrest?
No, Judge, I barely would indicate for the record as a jury trial is scheduled for April 22nd of this year. And I know we have other matters on at the same time. And one of the court wants to address that issue on run record.
Right, so obviously we won't proceed with that trial. I'm going to leave it on the calendar. If Mr. Fish appears for some reason at that time, then the court will have him arrested on a bench warrant and we'll go forward from there.
We're going to thank you.
Thank you. People versus Kelsey Nichols, case number 226453.
Your Honor, my call that people.
And ma'am, you're Miss Nichols?
Correct.
Okay. And this is a case where Ms. Davis, the probation department is recommending early discharge from. And Mr. Roll, I believe we set this for hearing today because the people have objected to that.
And again, that's correct. And the people, if I may address that, Judge.
Sure.
Thank you. This is a situation where the people objected to the early discharge. It's my office's position that defendants who physically assault police officers don't deserve a specifically early discharge. As indicated in the file and as became very clear, this is a defendant who fought with multiple police officers at a blood alcohol of 2.11. She kicked and attempted to bite police officers. And in this particular case, she was given 30 days jail with 18 months probation. Now, I understand the court has the discretion to do it, and I don't object to that being the case. However, I don't like necessarily the precedent set, as I indicated earlier this morning, on another circumstance where the defendant physically assaulted police officers. We don't believe lenient sentences, much less early discharges, as in this case would be appropriate.
All right, thank you. Ms. Davis, have you been the supervising agent?
I have not. Agent McFalda has been supervising her in Crawford County.
Okay. Obviously, she meets all the statutory requirements for early discharge. Do you have any other information that you can provide?
I don't. She's employed full time. She's paid in full. Reports as directed. Has attended counseling with no issues, and he was in agreement with it for the discharge.
Okay. Ms. Nichols, is there anything that you wanted to say about this?
Yes.
Oh.
I believe that I have done all the course that have asked me to do. I've gone above and far to prove that this was a mistake. This was not a lesson that needed to be learned. People make mistakes and I am a person. As far as what I deserve and what I don't deserve, I mean, I did not ask for early dismissal. That is something that my POs have stated that they think that I am ready for, that they believe that I deserve. I'm not here to argue whether I deserve it or not, but to say that I have done my counseling, my AA 6 months prior to my sentence date, that I have continued to do so after my sentencing date, after jail time, after work camp release. I have jumped through every hoop that this court has made me do. And I am still continuing to do counseling. I go on the 8th. I still go to AA regularly. I'm coming up to my 14 months of being sober. So if you would like to further keep me on, that is fine. I just don't believe that the paperwork is honestly necessary. for Mr. McFalda. He's been great. Danielle has been great, and I have no reason to go out and mess up what I have already corrected.
All right, I did have a chance to review this file as part of my consideration initially when I got the petition for early discharge and was notified that the prosecutor was objecting. So I had an opportunity to review things to refamiliarize myself with your case and to bring myself up to speed with how things have gone on probation. Under the court rules, the court's required to have a hearing when there is an objection to early discharge, which is why we're here today. Although I certainly appreciate Mr. Rolla's position, it sounds to me more like a general position and not specific to anything that you have or haven't done as part of your probation in this case. On the other hand, I've worked with Agent McFalda for 12 years. I know he would be putting this forward or recommending it if he didn't think that it was appropriate. And Mr. McFalda is not the type of guy to just let people off probation early for no reason. In the absence of some type of specific objection here, and in light of your full compliance with probation, I think this is the type of case that's contemplated by the change in rules in allowing early discharge. So the court is going to grant the petition for early discharge. Ms. Davis, you just have Mr. McFalda prepare that paperwork.
I will do it. Yeah.
And then Ms. Nichols, just make sure that you stay in touch with Mr. McFalda so that you know when you're officially discharged. Okay.
Yep, I still see him today.
Okay, great. Thank you. That's all for today.
Thank you.
People versus Veronica Walter, case number 246690.
Larry Brown on behalf of Ms. Walter.
Thank you. The record should reflect here in court today. Mr. Brown, can you tell me how we want to proceed on this case?
Your Honor, I had spoken with Ms. Walter, discussed the case as well as the plea offer, which would be plea to an attempted count, which would be an added count 3 or dismissal of counts 1 and 2. An attempted concealed carry.
So leading to an added count 2 of attempted.
Counts 1 and 2.
Actually, she's got that, it would be, I believe it had to count 3, Judge, and it would be dismissed of counts 1 and 2. I'll double check that.
The information I have is a 1 count complaint for carrying a concealed weapon.
I was not driving the vehicle.
And it's,
I was a passenger.
and in which case it would be an added count 3 of attempted CCW, which would be 750.227 bracket A bracket. Or in this case, 224, I guess.
What would be count 2?
I'm checking on that now, Judge. Thank you.
Yeah, Your Honor, I was looking at the complaint, but when I look at the information, there is a 1 count.
I think originally there was a complaint that was filed originally with 2 counts, but then a corrected amended information came after we may have been determined that the defendant was not the driver. So it would actually be an added count 2.
Oh, very good. Okay, so Ms. Walter, you would be pleading guilty to an attempt carrying a concealed weapon as an attempt that would have a maximum possible penalty of 2.5 years.
I understand.
Okay. Have you had a chance to talk to Mr. Brown about this agreement?
Yeah, I was told that was the best offer I was gonna get.
Okay. And do you want to proceed with that today?
Yeah,
Okay. Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, Your Honor.
Thank you. Are you currently on any kind of probation or parole?
No, sir.
And as I said, as an attempt, the maximum possible penalty for this charge would be up to 2.5 years. Do you understand
I
that?
understand.
With that in mind, what is your plea for this charge today?
Okay.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all of those rights,
I do, Your Honor.
and you understand that you're going to be giving up and waiving all of those rights, including the right to have a trial by pleading guilty.
I do, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
It is, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
The information says this happened on April 28th, 2023, so almost a year ago now.
Yes, sir.
Is that the right time frame?
Yes,
And on that date, were you here in Otsego County?
I was.
And while you were here in Otsego County, you have possession of a pistol.
I did, Your Honor.
And is that concealed in some way? Were you carrying that on your body?
Yes, sir. It was on my hip in a holster.
And did you have a permit that would allow you to carry that weapon?
No, I did not, Your Honor.
Roll are people satisfied with the factual basis?
Yes, Judge.
Mr. Brown?
I am, Your Honor. I also believe the court has complied with statute, court rule, and I'm unaware of any promises, threats, or inducements outside of the record.
These are also satisfied with the first Code statute, and we are aware of no such promises or inducements down in the record.
Ms. Walter, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave court today, you're going to meet with Ms. Davis. She's going to set up an interview with you, okay? Yeah. People versus Eric Garrison, case number 236651.
The record trial, my friend, that's people.
Clear on behalf of Mr. Garrison.
Right, this is the date and time set for a sentencing hearing in this case. Mr. Garrison, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that?
Yes, I do.
Okay. And Mr. Brown, are there any additions, deletions, or corrections to that report?
No, there is not. No.
I believe this is a
Please name this.
misdemeanor, okay. Mr. Rowland, any additions, deletions, or corrections?
Actually, Judge, I think it's what amounts to a typo graphical error. The restitution in this case is actually 524.97, not 524.90 as indicated in the SIR.
PSI says 534.90.
I'm sorry, 534.97, not. Sorry, that says 534.90. That's on page 2, Judge, and it should be 534.97.
Oh, thank you. Any other corrections?
No, Judge, thank you.
Anything on behalf of the people for allocation?
Judge, this is a one-year misdemeanor. The recommendation, with the exception of the correction I just made, appears to be appropriate. Thank you.
I would agree, Your Honor. I would ask the court to accept the recommendation, and just for the record, Mr. Garrison did inform me that he has that restitution with him.
Okay, Mr. Rolla, does he need to pay that to the clerk, or does that need to go to your office?
If it's post-judgment, it would go to the clerk. If it's pre-judgment, it goes to our office.
Okay, all right. Mr. Garrison, anything that you wanted to say?
I want to start by thanking my attorney. He's helped me get through this process. I don't know much about what it is I'm dealing with, so it's been a huge help of understanding things, being able to learn not only the lesson of the crime, but how to conduct myself as a person. I went through counseling, I've done all kinds of stuff. I know that's not really what I'm trying to say is I'm working really hard to get my life back to where it's supposed to. Not the choices that I made mistakes. And I just want to be accountable. I want to be able to move forward, take care of my messes. Clean them up front, be responsible. Just put this one down.
All right, thank you. I did have a chance to review the report prior to today's hearing, so I'm familiar with the circumstances here. There's also information in there about your background and personally your circumstances as well. I do think that this is an appropriate resolution. Number one, in cases like this, the court's main concern is that the victim's made whole. Sounds like that's going to happen today. I believe that was part of the agreement as well. I also think based on your record and your past history that it's appropriate to give you an opportunity through just fines and costs in this case. Court can punish wrongful conduct in a number of different ways. One of those ways is jail time. The other way is through financial penalties. And I think given the nature of the circumstances here, that's an appropriate punishment. So the court is going to, number one, order that you serve 2 days in the Otsego County Jail with credit for 2 days served. The court is going to order restitution in the amount of $534.97, which the court is going to order that you pay before you leave the courthouse today. A crime victim's assessment of $75, court costs of $325, attorney fees of $350, and a $50 state cost. You have the ability to seek an appeal of this sentence. If you wanted to file an appeal, you would need to do that within the next 21 days. If you have more questions about that, then you can ask Mr. Brown. He'll be happy to explain that process in more detail to you. But it's important for you to know the time frame cut off. Other than that, Mr. Rolla, anything further that we need to address?
People, thank you.
Mr. Brown.
Nothing further, thank you.
Mr. Garrison, that's all for today. Good luck.
Thank you.
People versus Mexico, Cory, Mexico.
I believe he's lodged, he just went down.
Oh. How long has he been lodged? Wasn't on my jail list.
Oh.
Your Honor, I thought it was lodged in Wexford.
Oh,
There was a bench warrant out for his arrest, Judge, that was issued for his failure to appear on March 7th, 2024 for his PSIR interview. Whether he's held at Wexford on that or on other charges that I am on.
okay, he must have misunderstood me this morning. Take it down.
Okay, got it. So do we know for sure that he's lodged in Wexford?
I'm looking right now.
Okay.
My violent information, Your Honor, I believe he's going to be there till May.
I know for the plea hearing, he was not lodged anywhere.
I received a call from his mother actually informing me that he was lodged. I did receive information he failed to appear for his PSI sentencing. The information that I have is that sentencing was scheduled for March the 7th. And the information I'm showing from Wexford indicates that his booking date was March the 5th.
Are you Mr. Mexico's mom?
Yes.
Okay, I don't want you to say anything to me or on the record, but Mr. Brown, if you want to.
Your Honor, he is lodged in the Wexford County Jail. It appears for Kalkaska County. because their jail is closed. He is lodged there. So if you want to adjourn this with that information, then Mr. Delia can now complete that PSI.
Okay, adjourned anyway, Judge, because the court doesn't have a PSA on to proceed.
Yeah, just one brief moment. Your Honor, are we still on the record?
Yes.
Apparently he is downstairs. They apparently moved him yesterday morning.
Okay. All right, so either way, we're not, gonna be able to proceed with sentencing today. So I'm just gonna have him remain here at the Otsego jail, and Ms. Davis, if you can just let Leo know.
Judge,
We don't need 10 minutes.
just to sort of complete the record, I do now see, after I've done some further checking, our office did send a writ to Westford County, and that's why she was transferred here.
Okay. So we'll reset this for sentencing hearing as soon as we can get the PSI completed. Anything further, Mr. Rowland, on this file?
Are they, Your Honor? No,
Anything?
Your Honor, nothing further.
Mr. Brown?
No, Your Honor, thank you.
Ms. Davis, is there anything else that we need to do?
I'm just making sure if it was on a writ. Do you have to do an order to keep him here, or is he gonna be
Yes.
returned?
Yeah, please. Okay, thank you. People versus James Morris, case number 246685, and I know he has lodged.
Yeah, I told him very bold stuff, so probably.
All right, we'll take a short recess until we have Morris present.
And advise the court too that we do have a victim who wishes to speak in that case.
Okay. Be in recess for about 5 minutes.
Madam, may we approach a moment?
Yes. Mr. Elma, if you can go to the podium. We're on record in People versus Maurice Elma, case number 23-6665. Record should reflect Mr. Elma's presence here in the courtroom today. I could have counsel put your appearance aside.
Larry Brown on behalf of Mr. Elma.
Okay, so this is the date set for sentencing in this case. Mr. Elma, have you had a chance to go through the pre-sentence report and speak to Mr. Brown about that?
Yes, sir.
Okay.
Sir,
Yes.
could we speak up? I had a difficulty hearing.
It's hard of hearing.
All right. Yes, I will. Let me know if you have trouble hearing, okay?
Thank you, sir.
All right. Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor, and no challenges to the scoring.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
Probation is well, that he's entitled to 28 days credit. It said 2 in the report. I don't know if that was a typo or what, but it should be 28 days.
Okay. Mr. Brown, is that correct from your standpoint?
Yes, that actually would be, Your Honor.
Mr. Rolla, anything you want to say on behalf of the people for elocution?
Yes, Judge, and I'll speak up for Mr. Elma's benefit. This defendant who was out on bond for operating while intoxicated, he again, for some reason, chose to drive after continuing to use marijuana. Defendant's either lack of recognition or intentional denial of the danger he put himself and others in while operating under the influence and while pulling a trailer resulted in blood alcohol levels of 11 hydroxy delta 9 THC, 16 nanograms per milliliter, delta 9 THC, 38 nanograms per milliliter, and delta 9 carboxy THC, more than 100 nanograms per milliliter. This presents a clear public danger in addition to a complete disregard for the orders of the court in regards to his bond conditions. As reflected in the defendant's prior criminal history of 4 prior drunk drivings, items 3, 8, 15, and 16 of his adult record, as well as 4 additional controlled substance offenses, items 2, 3, 7, and 12. Incarcerated this defendant is necessary, literally, to protect our society and this community. Thank you, Your Honor.
Thank you. Mr. Brown?
Your Honor, Mr. Elma is 60 years old currently. He's led a life of crime and he knows it. It has taken him a very long time to come to the realization that he's going to die. I mean, it's going to kill him. And honestly, I believe there was a part of him when I was speaking with him that he was so miserable, he wanted to kill himself. He doesn't want this life for him. He is self-employed. It is not making a lot of money, but he is continuing at that. He accepted responsibility fully. I think the court got the street wrong that he was driving on. He corrected the court to make sure they got the right street. He had no qualms stating exactly what he did, so he does accept responsibility. He helps take care of his mother. He does have the support of his family and friends. He does have some good qualities. Unfortunately, he has an addiction to alcohol or marijuana, which many people don't think it affects them the way that it does. And we see it in this courtroom every single day, how it affects people. And not just Mr. Elma, the person standing here, but the people in the community. And when he's standing there in this orange outfit, it affects his family and friends. It's going to affect his mother. It's going to affect a lot of people. He really wants to get into some rehab. I don't know if he's ever been in an intense inpatient rehab, which is what I think he actually needs, to be monitored, to get his life back on track, because at his age, he's not going to live very long if he continues down this road. I think he knows that, and I would ask the court to take those things into consideration when fashioning the sentence.
Thank you. Mr. Elma, was there anything you wanted to say today?
Yes, sir. After this has happened, I know I've had problems in the past. This is the first time in my life I've uttered the words, I want to quit. Because I can see where this is going. And also from health problems with breathing. I used it as a crutch. and to repress memories that I have from younger childhood that I don't want to remember, but there's got to be another way for it. And I realize also, as Mr. Brown said, I contemplated suicide because I don't know, and but I've understood now because it didn't happen, that God must have an alternative motive for me. And I know I done wrong, and I'm here willing to accept my punishment for what I've done.
All right, well, I read through the report, so I'm familiar with your circumstances, your history, and what happened in this case. And your history, I think you definitely have a problem. Number one, with substances.
Yes, sir.
And number two, with driving while you're using those substances.
Yes, sir.
This is your 5th conviction for either driving under the influence of alcohol or driving under the influence of drugs. So you continue to reoffend over and over again, even when you were on bond, like Mr. Rolla said. You know, I don't think there's any question that you knew you weren't supposed to be using anything and then driving, and you continue to do that. You have 6 convictions for driving on a suspended license or letting someone else drive your car with a suspended license. So that indicates to me that, you know you're not supposed to do that. You continue to do that over and over again as well. And both of those things place our community in danger. And you've been on probation 7 times. You've had 7 prior jail sentences of varying lengths. None of that has done anything to change your behavior. And so now, in my view, it's time for something different. Number one, because those previous lesser consequences haven't worked. And number two, as Mr. Rolla said, for the safety of our community, so that, because I don't have any confidence that you wouldn't use marijuana or alcohol and drive again if you were given the opportunity. Because you've done it over and over again, regardless of the consequences and regardless of knowing that you weren't supposed to do it. And so I think it's time for a different type of punishment here. And so that means prison, and your guidelines call for up to 23 months. The court is going to sentence you within the guidelines at 18 months. Again, I think that sentence is justified by your prior conduct, by your continuing to reoffend in the same ways over and over again, place yourself and the community at risk. And because, again, 7 prior jail sentences, 7 prior probation terms, it doesn't make sense to keep doing the same thing over and over again and expecting a different result. So I think a different type of sentence is warranted in this case. The court is going to sentence you to the Michigan Department of Corrections for a period of 18 months to 5 years. You do have credit for 28 days served. The court is going to order that you pay a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, a reimbursement for drug testing of $200, and a $68 state cost. You do have the ability to appeal this sentence. Mr. Brown, will you provide Mr. Elma with an acknowledgement of his appellate rights?
Yes, sure.
Yes, sir.
Your Honor, he has, or I do have an acknowledgement. I'm tendering that to the court.
Mr. Elma, you are remanded to the custody of the state at this time.
Okay.
Your Honor, I believe that is my answer.
Thank you. Mr. Schroeder, you ready with Mr. Williams' case? Okay, People versus Jesse Thomas, case number 6608. record should reflect Mr. Thomas is present here in court today. If I could have counsel put your appearances on.
For the record, Your Honor, my phone will be out to people.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Thomas.
We have this set for entry of a plea today. Mr. Trush, is that how we're going to proceed?
Your Honor, I would say we're incredibly close. We'd had this set out previously so we could get the restitution taken care of. Mr. Thomas tells me he should have the restitution to me by the end of the week, so I can get to the prosecutor. I would ask the court for one more status conference. If we can make it the plea cutoff, I think that would be an appropriate way to proceed. But again, I think we're very, very close.
Mr. Rolla, do you have any objection to that?
No, Judge, we have over $3,600 in restitution. Obviously, the people would like to see the victim reimbursed as soon as possible.
Okay, the court will set this for one final hearing in about 30 days. And so, Mr. Thomas, between now and then, just make sure that you stay in touch with Mr. Trush
Yes, sir.
about paying any restitution, okay?
Yes, sir.
Thank you, that's all for today. People versus Jesse Williams, case number 246673.
The record, Your Honor, my phone will be out to people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Williams.
Is Mr. Williams present here in the courtroom?
I do not see him here.
Have you had any contacts with Mr. Williams?
I would, Your Honor. I have, Your Honor. Just to update the court sort of on where we're at. At the last hearing, I indicated we were looking to get some mental health records that we wanted to provide to the prosecutor. We have got those records. I provided to the prosecutor. I actually met with the prosecutor talking about this case yesterday. I spoke to Mr. Williams yesterday evening. I'm really not sure why he's not here today.
Mr. Rowland.
Judge, I have no idea why Mr. Williams is not here either, especially in light of the type of the nature of the charges we have, where he is alleged to have seriously attempted to try and injure some police officers, trying to get away from them. I don't know, I'm checking now my file to see about prior non-appearance. I do note that this was adjourned for 60 days after February 7th. That was, of course, a complete mental health record, which Mr. Trees now done. Don't see prior failure to appear going all the way back to December 2023.
Yeah, I don't see anything in my file either. And this matter was recently found over without any prior failure to appear. The court will set this for show cause, and in light of Mr. Trush having had recent contact with Mr. Williams, the court will set this for show cause hearing at the court's next available date. Mr. Trush, if you can inform Mr. Williams, he needs to be prepared with an explanation for his failure to appear today.
Absolutely, Your Honor.
We're a little ahead of schedule. Ready on the Gense matter. Mr. Rose, do you have everybody here that you need for that one?
I believe so, Judge.
I don't believe Mr. Gense is here yet. I'm not seeing him come in. I would suggest, I think we have Mr. Lundy up. He is lodged in the county jail. So.
Okay, let's take a short recess. Proceed once Mr. Gense is here.
Sounds right, Judge.
All right, thank you.
Right behind me.
Mr. Trush, is Mr. Gense present?
He is not, Your Honor.
We'll go on the record in People versus Ethan Gense, case number 236546. Both counsel are present. This matter was scheduled for 3:30. It's now 3:35. Have you had any contacts with Mr. Gense?
I did, Your Honor. In fact, I just got off the phone with him. Apparently, Mr. Gense thought that the 3rd is tomorrow. He believed that it was the 3rd and that meant Thursday at 3:30, not today. So I called him and I'm like, where are you? And he is not within a distance that he could be at the court within a reasonable time.
All right, Mr. Rolla.
Judge, again, I don't know if that's, I don't doubt that's what Mr. Trush was told by his client. I just have quite frankly some difficulty with the veracity of the statement coming from his client. We have a victim here who is prepared to give a statement to the court, and I can ask her, and again, the court has discretion to do this, as to whether or not she'd like to make a statement in advance and not have to come back, if the court allows it. If not, we will have to reschedule sentencing, obviously.
Okay, first of all, Mr. Rolla, I am going to ask that you prepare a bench warrant for Mr. Gense's arrest. Given the circumstances, given that this is a sentencing hearing, he's no longer entitled to pretrial release. And despite contact with Mr. Trush, I'm under some circumstances I might simply allow for a show cause, but given the nature of the charges here, given what I read in the PSI and some of the other documentation, I think it's appropriate to issue a bench warrant and revoke Mr. Gense's bond at this time. So once that's presented, Mr. Rolla, the court will sign that. Mr. Trush, if you have further contact with Mr. Gense, I'll just request that you notify him that a bench warrant is going to be issued and he needs to turn himself in. Otherwise, we'll proceed at such time as he's arrested and brought before the court, and we'll reschedule sentencing once Mr. Gense is in custody. It's the court's preference to have a sentencing hearing, a complete sentencing hearing. In other words, having the crime victim give their statement at the time with the defendant present. However, I also understand that in this case, this type of case, it's difficult for victims to give statements sometimes, and that you're geared up for something, sometimes you don't want to have to come back and do it again. So I'm open, Mr. Rolla, if you and your victim's advocate want to talk to the victim, if they would rather make their statement today and not come back later, I'm open to doing that. Let's find that out first, and then I'll see what Mr.
The victim indicates she will return for a later date, so sentencing can be conducted in a single hearing, Judge.
Okay, all right. So again, the court will issue a bench warrant for Mr. Gense's arrest, and we'll proceed further once he's arrested and brought before the court. Thank you.
Thank you.
You can have Mr. Lundy.
Yes, Your Honor. Your Honor, I would indicate Mr. Williams is present.
Okay. People versus Williams, we'll recall that case.
Representative, I call that people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Williams.
And remind me, Mr. Trush, how do you want to proceed on this case today?
So, Your Honor, I already gave the court some of the background. We did provide some mental health records to the prosecutor. The prosecutor had discussed with me a couple different sort of permeations of the offer, as well as some clarification he'd like on some of these records. So I would ask for a short adjournment so that we can narrow in exactly where we're gonna be. I expect at the next hearing, we'll be in a position to either take advantage of an offer or ask that the court docket the matter for a trial.
Mr. Rolla, any objections to that?
No, Judge, as we've indicated on 2 earlier occasions, Mr. Trish and I met yesterday for well over an hour. This was one of the many cases we discussed, and he was provided with information on some additional matters, which I think he needs to explain.
Okay, so we'll set this for a status conference plea hearing in about 30 days. Mr. Williams, it's important that you stay in touch with Mr. Trush between now and then. It's also important that you're here on time for your court hearings, okay?
Yeah, I was here too, sir.
Okay.
I just didn't know to come in and I was
Oh,
talk to him first. I'm sorry.
okay, that's all right. Thank you. Are you gonna need to speak with Mr. Lundy or will you be ready to go on this case?
I think we're ready to go right into this one.
Let's just stay here in the courtroom and be brought up right now. Yes, sir. That's not set, I guess, until 4, so
Right.
let's see if Mr. Brown appears. Mr. Brown earlier said he didn't have any more cases back. Mr. Trush, are you ready on Mr. Pfit's case?
Yes, Your Honor.
Mr. Pfit, if you'll come forward, please. The record should reflect Mr. Pfit's present here in court today. If I could have counsel put your appearances on.
For the record, Your Honor, my phone is people.
Your Honor, Richard Trush on behalf of Mr. Pfit.
This is the date and time set for sentencing in the 2 new files as well as in the probation violation file. Mr. Pfit, you had an adequate opportunity to go through the reports with Mr. Trush and talk to him about that?
Yes, sir.
Okay. Mr. Trush, are there any, dealing first with the probation violation report, are there any corrections that need to be made to that?
Your Honor, I think I received the probation violation report. I just received one.
Chance to go through that.
Yeah, I'm sorry, I may actually. Yeah, I actually do have 2 packs, yes. I'm sorry.
You need a minute to go through it with me?
I don't believe so.
Okay, all right. And then as to the SI on the new files,
No, Your Honor.
are there any challenges to the scoring?
No, Your Honor.
Or do people have any additions, deletions, or corrections?
Only one correction, Judge, in regards to the report dated April 3rd, 2024, in regards to case 246683 FH. I had on page 2, under item 3, case number 246683 FH. They indicate attorney fees of 3.5. It's a typo. It should be 3.
Thank you. Okay.
Other than that, no additions, deletions, or corrections as the body report or challenge says this one.
Thank you. Mr. Trush, or I'm sorry, Mr. Rolla, anything on behalf of the people for allocation?
Judge, this is a bit of an unusual case. Perhaps maybe it's reflective of where, unfortunately, some persons and segments of society are going. Mr. Pfit, in case 226401, that's the one where he had the methamphetamine in the thermos case, we tried to hide it. It just shows perhaps maybe the addictive nature of methamphetamines and what people will do to continue using it with its use to cover it up. As to the case in regards to in possession of a firearm, I use the rifle, the 3030, pursuant to MCL 75239, has to be confiscated and condemned. Other than that, Your Honor, I think other recommendations are probably good.
Thank you, Mr. Trush. Anything on behalf of Mr. Pfit?
Yes, Your Honor. And I'll keep it somewhat brief. I tend to actually agree with the prosecutor. I think this does show sort of the addictive nature of methamphetamine and how, the grip it can have on people. Mr. Pfit, I think, is trying to address this problem. He wants to address it. But as the court knows from, being on the bench and seeing the dockets, I mean, this is a drug that permeates our community. It is a drug that affects a lot of people in our community, and not just limited to methamphetamine, but addiction in general. It is difficult to beat, and even when you do have success, it's a lifelong thing. And he may be successful for a period of time and may struggle and relapse. So I agree with the prosecutor in that sense. I think, this shows just, how difficult this process is. And for Mr. Pfit, I hope that it is sort of a wake-up call or eye-opening to vigilance. I mean, if he's serious about really addressing this and staying sober and staying clean, it is something that even when he's doing good, he has to stay vigilant on. He has to continue to work at it. Because I think that's where a lot of relapse happens, when people do feel like they're doing well and they feel like they're in control. Maybe they don't need to go to meetings, or maybe they don't need to take the same sort of precautions that they would otherwise. So I agree with the prosecutor in that sense. Insofar as a firearm offense, I guess I would indicate to the court the circumstances here, I think, are less serious than some of these that we see. And I mean that in the sense of, I don't think there's a suggestion of doing anything overtly dangerous with the firearm. I think he was hunting. So again, still not appropriate for him to have one given the history, and that he hasn't taken steps to restore his firearms rights if he wanted to do so. I also think it is worth the court taking into account that there wasn't anything overtly dangerous about what he was doing. I think that the recommendation is fairly reasonable. I would ask the court to consider, while following that recommendation, potentially making him eligible for the work camp program at some point during the term of incarceration, or any other alternative that may be available to him during that.
All right, thank you, Mr. Pickett. Was there anything you wanted to say today?
Oh, yeah, on the one where I tried hiding the bag and put in my coffee cup, that was my first drug charge. This drug charge, I got pulled over. I admitted I had it, gave it to him. It's a very small amount. Same thing with guns. I got caught and getting the gun, So I mean, I went to rehab right after I got the second meth charge. Did 45 days in Bear River. I've been sober ever since. Been reported for probation every 2 weeks. So I mean, it's been waiting to go forward and get this part of it over with.
Okay.
But I've been sober almost a year, be a year in June.
All right, I did read through the report. I'm familiar with your background as well as, what happened in this particular couple of files here. And, in the spectrum of seriousness of crimes, it's clear that you weren't in possession of this firearm to try to commit some other type of crime, to assault somebody. It's pretty obvious from the facts that you were out hunting. You shouldn't have been using that firearm. But the court doesn't necessarily have any public safety concerns based on the conduct. It certainly was wrongful and deserves a consequence. But I think that goes to the level of consequence. Same kind of thing with your possession charge in this case. Shouldn't have had it. I'm glad to hear that you're sober and staying sober. I hope that continues. The only other thing I would say is you saw your guidelines in this case. You got prison at the top end. You've had a number of different times on probation. You've had a number of different jail sentences. To the extent that you continue to commit felonies and get convicted, you're going to be running out of chances to stay local, and you're pretty much looking at prison from here on out. So it's in your best interest to remain sober, to do the things that you need to do to keep yourself out of trouble, not do what I kind of view as just kind of stupid things, like hunting and carrying a firearm when you know you're not supposed to. It just opens yourself up to what from now on is going to be a really serious sentence, and it's not going to leave whatever judge is in front of you with much option other than sending you to prison. So, and I don't think you want to go to prison for something like hunting with a firearm. You shouldn't have. No. And it's something that's just easily avoidable if you're exercising good judgment. So, all of that to say, I don't think your actions, although the court would be within the guidelines to send you to prison today, I don't think your actions in either of these cases warrant that. The court is going to sentence you as to the possession charge to 9 months in the Otsego County Jail. You do have credit for 4 days served. Court costs the amount of $325, attorney fees of $350, and the state cost of $68. As to file 246684 possession charge, also 9 months with credit for 2 days served in that file, a crime victim's assessment of $130, and the state cost of $68. as to count 2 in that file, operating with a suspended license, a $50 state cost. All of those sentences to be served concurrently. I don't have any objection to your release to work camp during those 9 months. If you're employed or if you just participated in the work camp program, I think that would be appropriate given the nature of the charges here. You do have the ability to seek an appeal of these sentences. Mr. Trush is going to provide you with an account of rights.
Court could order condemnation on the local judge.
Yes, and condemnation of the fire.
Probation violation.
To be honest, the 45 days I didn't rehab, I didn't really complete rehab, but I was kicked out on a technicality for not taking antipsychotic medications, but my PO said that time would count. Is that part of this, or is it? It doesn't really matter too much. I mean, I got my time I gotta do, so.
Yeah, I mean, the only time that I consider giving somebody day for day credit off their sentence for rehab is if they successfully complete it. So. It's the worksheet. Can you, Joe, know Mr. Huffman on the
Veronica.
Yes. And then
You need to address that to the.
Oh, I'm sorry. Thank you. All right, and then with regard to the probation violation in this case, the recommendation of the Department of Corrections is simply that you be discharged unsuccessfully and sentenced to time served on that. I think that's an appropriate way to address that. So as to file number 26401, the court is going to discharge you unsuccessfully from your probation and sentence you to 147 days in Otsego County Jail with credit for 147 days served and preserve any outstanding fines and costs. Did we have the appellate rights on that one as well?
I do. I have all 3. So both the probation file and the 2 newer files have all been signed and dated.
All right. Thank you. Good luck to you going forward.
So no more probation or?
No. You're done.
That's my.
Good.
Mr. Brown, we're just waiting for the jail to get Mr. Huffman on video.
Okay, thank you, Your Honor. I apologize. I just totally forgot about it. I'm not used to having an hour between my hearings.
Yeah, no problem, understood, and if we get Mr. Hoffman on video, we'll proceed.
Thank you.
Okay, we just need you guys to unmute at the jail, please. Okay, I think we got you unmuted. Can you hear me all right?
Yes, sir.
Okay, we're on the record now in People versus Michael Huffman, case number 236599. And sir, are you Michael Huffman?
Yes, sir.
All right, thank you. We have Mr. Huffman present from Otsego County Jail by video. His counsel, Mr. Brown, is present by video as well. Mr. Roll is present here on behalf of the people in the courtroom. This is set for a status conference today. Mr. Brown, can you tell me where things stand in this file?
Yes, Your Honor. There was a plea offer made in this matter to which Mr. Huffman would plead to an added count 2, which would be an attempt for dismissal of count 1 as well as the habitual. That was contingent upon paying restitution. I tendered a check to Mr. Rolla this morning in the amount of $3,085.44. It has come to my attention that there has been another late fee added. However, Mr. Rolla did state that he would allow a little extra time for Mr. Huffman to pay the additional $150 or so.
And Your Honor, if I may approach, I actually have a written copy of that.
Sure, thank you. Is that a correct statement of the plea offer, Mr. Roll?
It is, as reflected in the documents I just handed to the court. The additional amount is, I think, $167.
All right, thank you. Mr. Huffman, were you able to hear that?
Yes, sir.
Okay, is that how you wanted to proceed today?
Yes, sir.
Okay. Can you raise your right hand, please?
Yep.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Huffman, are you currently on any kind of probation or parole?
No.
You understand that by pleading guilty to count 1, which is non-sufficient check funds as an attempt, that is a maximum penalty of up to 1 year.
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
Absolutely not, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
All right, this happened on or about September 12th back in 2022, is that correct?
Yes, sir.
Okay. All right, and did you write a check that would cause some money to be withdrawn from an account of Earthworks Enterprises?
Yes, sir.
And was that an amount that was more than $500?
Yes, sir.
And was that check drawn upon Forefront Credit Union here in Otsego County?
No, it was in Antrim County.
Okay. Did you, when you wrote that check, were you here in Otsego County?
No, I was in Antrim County. They delivered the gravel, sir.
It was presented here for payment, Judge.
Okay, got it. Do you contest at all, Mr. Huffman, that that check was presented here in Otsego County for payment of the funds?
No,
With that, Mr. Roller, are you satisfied with the factual basis?
People satisfied for sufficient factual basis to accept defendant's plea to added count two. Courts comply with Portland statute, and we're aware of no threats, promises, or other inducements not placed on the record. I further indicate for the record, I can confirm that Mr. Brown did provide my office with a check for most of the restitution, except for the balance of $167.95, which we have no objection to the court imposing as a condition of sentence.
Thank you. Mr. Brown?
I agree with all of the prosecutor's statements, Your Honor.
Thank you. Mr. Huffman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing, and you'll be notified of the date and time of that hearing. Prior to that, you'll be contacted by somebody from the probation and parole department for a pre-sentence report. Mr. Brown, anything further we need to address on your side today?
Not at this time, Your Honor. Thank you.
Mr. Rolla?
No, Judge. Thank you.
All right, thank you. That's all for today, and the court's gonna
I
disconnect.
thought, hey, can I get out? Hello?
Mr. Huffman, what was that? I'm sorry.
I was trying to talk to you guys to see if I could get out on a bond or something for, so I can help my mom out. She's 80. She's in the courtroom right there. And, you know, I got a biopsy coming back. I don't know when that's gonna come about. All right. They think I may have stomach cancer, sir. That's all. I'm trying to do the best I can right now, and I've been nerved up for about 6 weeks now over it.
Okay, it looks like you're being
And
held
I'll
without.
guarantee you,
Let me just see where we're gonna go with this. It looks like you are being held without bond based on your failure to appear a number of times in this case. So that's why the court entered that order back on March 27th.
Can I say something?
No, I'm sorry, ma'am.
That's my mom trying to speak.
Yeah. Mr. Rolla, do the people take any position on that bond?
No, Judge. In fact, I can't obviously speak for the defense, but people in the, as I said, the bond was that used to be held pending sentencing or plea in sentencing, depending on the cases. This is a misdemeanor. I don't know if the court needs additional information to proceed to sentencing or not. If you do, you can do that at this point in time, or if the court wants to readdress bond, that we leave that to the discretion, obviously.
All right, so Mr. Huffman, given that you've entered the plea today, given that the majority of the restitution has already been paid, the court is going to reinstate your personal recognizance bond.
Okay, thank you.
So, but I don't know if we're going to be able to get the paperwork yet tonight to get you released because the court closes in 9 minutes. So, Mr. Brown, I'm going to need you to prepare an order reinstating Mr. Huffman's bond, and Mr. Huffman, you'll be released as soon as the court can get that and get it signed, okay?
Okay, you know when that will be, Your Honor? My family's there, that's why I'm asking, sir.
Yep, I understand, but the jail has to have that paperwork before they can release you, so it may be tomorrow morning.
Okay, that will be fine. You know,
But
thank you.
It shouldn't be any later than that.
Okay, thank you.
Okay. Okay, thank you, that's all for today. That concludes the court's afternoon docket.